My name is Spencer Wilkinson, and I'm an attorney at Jackson White Law. I practice guardianship law in front of the probate courts of Arizona. Today, I wanted to talk about what to expect at the initial hearing set on your petition for appointment as a guardian and a conservator. When you first file your petition for appointment with the clerk of the court will set a hearing date and time for you and will give you a document called a notice of hearing. This notice of hearing gives you the information needed on how to access or appear at your initial hearing. Currently, there's a presumption that all initial hearings are held virtually in Arizona. That means that you can appear by telephone, by Microsoft Teams, or by Zoom. Follow the instructions on the notice of hearing to know how to appear virtually at your initial hearing. When you first appear at your initial hearing, the first thing to happen will be a roll call performed by the judicial assistant to try to figure out who everyone is and make sure that no important parties are missing. After this roll call, the judge or the commissioner assigned to your case will appear and will call the case. That means they'll say the case name, the case number, go over the roll call, and then swear in the petitioner or the person asking to be appointed as a guardian or the conservator. After you're sworn in to provide some testimony, your attorney, if you have one, will ask you some questions. The court-appointed attorney for the proposed ward will ask you some follow-up questions, and the judge or the commissioner assigned to the case can also ask you some questions. Because these initial hearings are 15 minutes in length, you should expect your testimony to be quite short. However, if there is an objection to your petition for appointment from either the proposed ward, from a family member, or from any other interested person, the judge or the commissioner assigned to the case will not let you testify that day. Instead, they will set a hearing in the future called an evidentiary hearing or a trial. However, if there is no objection, then the judge or the commissioner will allow some testimony to take place that day, and they will decide at that hearing, typically, whether or not the statutory burden has been met and the need for a guardian and a conservator has been shown. If that's the case, the judge or the commissioner will announce their decision at the hearing and let you know whether or not you have been appointed as a guardian or a conservator. The procedures are a little different if the hearing that is set is on an emergency petition for appointment, or if the hearing is a contested evidentiary hearing or a trial. If you're looking for some information on what to expect at those kinds of hearings, this YouTube channel may be a good resource for you as those videos are uploaded. If you have specific questions on what to expect at the initial hearing set on your petition for appointment as a guardian or conservator, it may be a good idea to talk with an attorney to help give you some guidance on what to expect so that you can be best prepared for your hearing